Thank you very much. I'd like to start this morning by telling you about an employee whose mother had stage 4 breast cancer. She went to her supervisor and she said, "I need leave under the FMLA." The supervisor reacted angrily, told her that she didn't like those plans for her to take leave, and then started treating her very differently. The supervisor had been very pleased with her performance up until that point, but now started scrutinizing her work and finding fault. She made comments repeatedly like, "You are hurting our business, you're not here enough, you're not here when we need you." And when the employer needed to reduce the size of its workforce, the supervisor selected this woman for layoff even though she had more seniority than others who were retained. And this is not an unusual story. I hear stories all the time, or I read them from the court cases. We have the woman who didn't get her normal bonus, and when she asked why, her supervisor said, "It's because you took time off to take your mother to the doctor's appointments." And that woman was fired. We have the man who took 4 non-consecutive FMLA days off to be with his dying father. His supervisor yelled at him in front of a workplace full of people and accused him of abandoning the company when there was work to be done. He also was fired. And the stories go on. So what is happening in this situation? We're seeing a clash of expectations. We have the supervisors on the one hand who are looking for what they consider to be the ideal worker. And that's someone who can work full-time, never take time off for child care or for elder care, can travel, can work overtime, can be available for emergencies. The problem is that model arose in the 1950s and 1960s when most households had one adult in the paid workforce and one adult at home taking care of the family work. Nowadays, it's very, very different. We know that about half of the workforce is female. We know that men are much more involved in family care. But importantly, we know that 83% of workers are in families in which all of the adults are in the paid workforce. So we have this clash between the reality of what's going on and this idea of what the supervisors are looking for. And that leads to family responsibilities discrimination, which is employment discrimination because of caregiving obligations. And it affects mothers and fathers of young children, as you would expect, but also pregnant women and also workers who provide elder care. So why does this arise? We know that bias is inherent in all relationships and that it affects decision-making, including personnel decision-making. It affects what we notice and what we remember. It affects how we interpret ambiguous information. It affects how we evaluate what we see and how we respond to what we see. And there's several common biases when we're talking about caregivers. One is that they're not going to be committed to their jobs. They're going to put their families first. Another is that they're no longer going to be dependable. We can't count on them to do their work. We can't count on them to meet deadlines. If they are in the office, they're likely to be distracted. They're not going to be as productive as the other employees, and they're going to be absent too much. They're not going to be available for those emergencies and for that overtime and for that travel. Now, there's no federal law that prohibits family responsibilities discrimination. There are some jurisdictions, some states, some counties, some cities that have laws that do specifically say employers cannot discriminate based on family responsibilities. And we see most of this action in the counties and in the cities, and they have a variety of terms that they use, such as you can't discriminate based on family status, parenthood, and family responsibilities. Some of those would cover employees with elder caregiving obligations, some would not. Importantly, for employers, some of those ordinances allow employees to get right into the courtroom and to sue for uncapped damages. So most employees are not covered by one of these statutes, and so they use a variety of different approaches. Some sue for sex discrimination under Title VII in state laws, some sue under the FMLA or the ADA, and some have fact patterns that allow them to sue for Equal Pay Act violations or ERISA violations. There's also a variety of common law actions, breach of contract, tortious interference, fraud, infliction of emotional distress. All of those are highly fact-specific. So elder care is the new area in family responsibilities discrimination. It's a very rapidly growing area. And we know from studies that about 17% of employees are currently providing care for an aging family member. And most of them say it impacts their schedule. They're having to arrive late, they're leaving early, they're taking leave, or they are working flexibly. We know about 42% of people say that they provided care for an elderly family member in the last 5 years, and we know that the need for caregiving is increasing rapidly. We know that we have an increasing number of employees who are providing care, not only because of the growing population, but also because we have people who are delaying their own retirement. Employees are staying on the job longer, and so they are on the job for more years when they are expected to be providing family caregiving. And so people tell us, we know from studies, that about half of employees expect that they are going to be providing care for an aging family member in the next 5 years. At the Center for WorkLife Law, we track family responsibilities discrimination cases, and we've seen a sharp uptick in the number of elder care cases filed in the last decade or so. I would note on this particular chart that the data for 2011 and 2012 is incomplete, so it looks like there's a tailing off, but I imagine once we have finished the research, that line will be trending upward. And so what is it that employees can do? Because if you are an employee who is being discriminated against because you're providing care for an aging family member, chances are you don't have a sex discrimination claim. Chances are you don't fit into many of those other categories that I put on the slide before. What we see is most employees are bringing claims under the FMLA if they're covered. Only half of employees are covered by the FMLA. But also, they can bring those claims only if the discrimination they think that they're experiencing is related to a request for leave or the actual taking of leave. There are two types of actions under the FMLA. One is interference, and you can bring that if you have been denied FMLA leave that you are entitled to, or if you've had your right to take FMLA leave interfered with, such as your boss saying you better come back to work early. The second type is discrimination or retaliation for requesting or for taking leave, and I think that's much more straightforward. One thing to note about the FMLA is not only does it apply to only about half of workers, but it doesn't cover a lot of situations in which care is ordinarily provided to aging family members. For example, it does not apply to care given to in-laws or to grandparents. Some employees also bring actions under the Americans with Disabilities Act. That has a provision that says you cannot discriminate against an employee because he or she is associated with someone who has a disability. Again, this is highly fact-specific. An example would be an employer who allows all employees to work part-time, except the employee who wants to work part-time so that she can take her mother to therapy. That would be an example of associational discrimination. One thing that's important to know about the ADA, though, is it does not require any accommodation. We talked with a man a couple years ago whose wife had MS. He would go home every day at lunch, give her medications, and he would feed her. He got a new supervisor. The supervisor said, "We have a blanket rule now. No one is allowed to leave the campus during lunchtime." There's nothing that the ADA can do for him in that situation because he is not asking for an accommodation. And one area that's a growing area, an area that has some promise for employees, are the local FRD laws that I mentioned earlier. Unfortunately, a lot of them have a very narrow definition of what constitutes family. When I showed you the earlier slide and I said a lot of these are based on family status, usually family status is defined as living with minor children or being pregnant or in the process of adopting minor children. So that does not help. So I'd like to close just by talking briefly about a few solutions to FRD for elder caregivers. One is we just need more information. We need more information about the biases that they are facing, and we also need information about what is actually going on in the workplace. What we see right now are the cases that make it into the courts, and those are very few. Training supervisors is absolutely key. They need to understand FRD. They need to understand what the bias is and how it arises. But very, perhaps obviously to us, but not to them, they need to understand the business case for retaining people who are providing care to aging family members. A lot of them think, caregiver, deadwood, get rid of them, we're going to be more productive. In fact, it's absolutely the opposite. And so when I'm training supervisors, I spend a lot of time working on the business case. HR needs to also be trained. They need to know how to handle FRD complaints. A lot of companies are providing resources to help employees who are dealing with aging parents. And then one area I would really like to focus on is enacting additional anti-FRD statutes that define family broadly enough so that it would cover elder care. And
I think we have about a minute.
Yep, thank you. I'm actually not going to show you these remaining definitions, but they will be in the slides if anyone wants to see it. I've just given examples of really good definitions and definitions that perhaps aren't quite so good. Thank you very much.